So today, for example, I had to tell the court why I thought an agreement that was reached at a mediation was in the children's best interest. My first submission to the court is that parties reached this agreement themselves. Now, that is not a factor in the Family Law Act. I think it should be. But at the end of the day, the parties reached the agreement. That is always in the children's best interest. That mum and dad reached it. It's not court imposed. It's not imposed by anybody else. It's just what these two want. So that's a great starting point for what is in their best interest.
So welcome today to Tracy, who's joining us on the Jim's podcast. And you're from Jim's Legal, and you've just joined us in a family law capacity. So Tracy, do you want to start off with first a bit about yourself and about your experience and what's made you want to come on board with Jim's Legal?
Yeah, sure, Joel. I've been a lawyer since June 2022. I did 2 years of articles, so I've been doing it for a very long time. I still have a passion for it and for helping the people that need family law advice in relation to parenting, property matters in particular. The reason I wanted to join Jim's Legal is because I just think it's an awesome franchise group. I loved hearing about Jim when he heard that Godfrey's had gone into liquidation and he was offering free franchises to people who had lost their position. So I felt like it was a really good culture and a good fit for me. Having said that, I am sort of slowing down a little bit. So I'm here really just to try to keep matters out of court, just to help people get through what can be a very difficult experience. There's lots of changes coming to the legislation. Court is the last place that people should be. And so I'm really just here trying to help people get through matters as quickly and as amicably and as cheaply as possible. And I feel I can bring that side of my experience to Jim's and the clients that will come from Jim's. And I just feel like it's a good mix.
Tracy, you've got a really good offer for Jim's franchisees. So do you want to just talk a bit about the offer that's available to Jim's franchisees to use?
Yeah, sure. What we're offering is 30 minutes of free advice. So by telephone is probably the best. The best way to contact me for a reach out for this phone appointment can also be by Zoom or Teams, is to email me so that we can then set up a time. Just because of my current position, I've got lots of matters still in court and a couple of clients that I'm still seeing. I also am a volunteer at Orange Sky, which is the portable laundry for homeless people. So if you email me, we can set up a time to have a free consultation for 30 minutes where we can get a feel for what's going on in your matter, talk about where we need to go from here, and hopefully just put you on the right path to where to from here. Then if you need continuing advice, our offer is that we will give you 25% off our normal rate. So our normal rate is $550 per hour. Well, actually, I think it's $600 now plus GST, sorry. And so for Jim's, I'll say franchisees, it's $450 plus GST per hour with that discount if you continue with us. But as I said earlier, my aim is to make things cheap, quick, and amicable. So we do all we can to keep prices down.
It should be music to people's ears, because if they've gone through some matters before, they would understand that it can be quite expensive family court. Well, that's sometimes a perception from people. So do you want to just talk real quickly about for franchisees, and obviously we hope to never get into this position, but let's say, for example, a separation happens and they've obviously got business assets and all these things involved and there's children involved. What sort of things come up? What should they be considering and what should they just know about? Unfortunately, if that does happen, what are some realities maybe of the situation and how you guys can help them?
That's a really good question, Joel. Probably the first thing we would be looking at is to keep lawyers out of it. So as I said, keep it amicable. Let's keep things as peaceful as we can. So have a conversation with your former partner, figure out what we're going to do in relation to, yes, the business, property settlement, parenting matters. If we need to take things further, then we get items value. That can be businesses, it can be property, any big ticket items, cars, etc. But we don't rush into that until we have had a conversation with the other side, figure out, is there agreement on values? Because that's the first step in property settlement. Work out what is the asset pool, then we work out who gets what. And there were many steps involved in that, which is why we'd need to talk about that further in our consultation with you. Yeah, that makes it sound simple. So where to from here? That's what we would be doing first. In relation to parenting matters, again, If we can keep lawyers out of it, we can make an agreement between ourselves. Nothing has to be committed in writing for parenting matters. It can be just an informal arrangement. Pick the kids up Friday, we'll take them back Sunday. Really, whatever works, keeping in mind, of course, what is in the children's best interest. That's what the legislation would say if we had to take the matter further. For property settlement, it's crucial that we have our agreement formalised in either a court order or a financial agreement. For parenting matters, you can have just an informal arrangement. You can just do whatever you like. Whether it's amicable or not, you don't have to have that formalised into an arrangement, but definitely you do for property settlement. That is parenting and property in a very, very quick nutshell. So hopefully that assists a little bit, but it's a great question, Joel, and obviously there's a lot to it, but hopefully that assists a little bit in really what we're doing. But my first approach is always, if you can have a conversation with your former partner, that is the best way that we can do it, rather than going and engaging lawyers and really spending $2,000 all of a sudden before you know it. $2,000 comes out of the asset pool, $2,000 is taken away from what you might be spending on your children, and things were fairly peaceful between the two of you. As soon as lawyers gets involved, that can often change a lot. So there's also ways to sort matters out without going to court as well. That's mediation. That would be my second choice, which the first one is negotiation. And then after that, we go to mediation. There's arbitration. That's another way of keeping things out of court if we have to. So there are lots of options. Every case is different and every matter needs something different. Lots to talk about, lots to think about.
You get the first step, just outline for me as a layman. Someone, let's say if something happens, would they come to you, is the first preference to obviously come to you and do it together as a couple, and you would, let's say, draft agreements based on what they're saying together, or would it just be a separate thing between, all right, they're engaging you to go but to their lawyer? Or what's the most cost-effective way to manage that at the start if people do, because obviously it can be very emotional, but if people are able to step back from the emotion, do it logically the best way, is that the best way to come together as a couple just to sort it out and get that you to flesh out the agreements? Or what's the best way for the first point of call?
That's another really good question, Joel. There are many cases where if husband and wife, partner and partner, whatever the case may be, have reached an agreement and they don't need legal advice, or they've had perhaps legal advice and they just want me to formalise it, absolutely that can be done. And it can be done where essentially not really acting for both, but I'm assisting both parties insofar as I'm drafting the agreement, especially for property settlement. As I said, that needs to be formalised into an agreement. So that can be done. I can do the document that formalises it, that says husband gets X, wife gets Y, or whatever the case may be. But it would be the case that I wouldn't be giving advice. Is this a good agreement for you, Mr. Smith? Is it a good agreement for you, Mrs. Brown? Yeah, I wouldn't give advice on that, but I can certainly draft the document to get the agreement formalised. So essentially, one lawyer acts for one party at a time, but I, a lawyer, could draft documents for both of you without necessarily acting for you. Does that make sense to you, Joel, as a layperson then?
No, well, it does, because obviously if someone asks you that question, you got two parties there, right? And it's hard to give a bit of a conflict between obviously both parties in terms of what you're saying. Yeah.
So if it means that you don't need advice, so if Mr. Brown said to me on the site, on the quiet, do you think I'm getting a good deal here? That's not a case that I could answer, because I would not be acting for Mr. Brown solely or Mrs. Smith solely. I'd be acting for the two of them for the purpose of drafting the documents. If Mr. Brown, and in fact what I would even say is you both should go and get your own independent legal advice if you want to. You don't have to, of course, but otherwise if you're happy with this agreement, we'll sign off on it, formalise it, everyone walks away with whatever the agreement provides. So yeah, that can be done. That's a way to make it be done even more amicably without engaging really anybody else, the parties.
And this is a really general question, but would you advise people to try and take the emotion out of it and look at it objectively? Because family law, I think it's got a common thing, like people, when there's kids and property and they might have not ended on good terms, relationships, sometimes people just forget about the actual logical outcome that should be achieved, and it's all emotional, and they will throw money at endless, mindless things. And I know that Jim in the past had that done to him, so he's very passionate about fairness in terms of family law and how the courts treat things. So how would you advise people to step back and let's say if it's not we hope it's an amicable split, but it might not be or something. So how do you guys deal with that, and how do you deal with those people where it's maybe, let's say, a bit more emotional?
At the risk of saying that's another really good question, Joel, that's also a really good question. I often find my advice to parties is come back and see me in a little while. Go and take some time to process the separation. You don't have to rush in and do everything straight away. If things are calmish, if you've got a place to live, if the house isn't about to be possessed by the bank, for example, and you're safe, let's just slow things down. Let's not rush to really pursue anything formal, because often as well, in the heat of the moment, parties think they're separating, but sometimes they're reconciling. That doesn't mean whatever you pull apart can't be put back together. But really, it's a great question because, yes, it is highly emotional. I feel, even though I was told many years ago when I was studying family law, we are not counsellors, half the time we are really there to be a sounding board to people, but at the end of the day, we're giving legal advice. But I find that if we're really too heated, if it's too emotional, if it's too raw, we just sit back, go and do what you need to do, talk to friends, talk to family, go see a counsellor, and then come and see me, and then we'll figure out what we need to do. Sometimes people come to us and it's prior to separation, so then they get some advice, and that's probably a really good way to do things. Then they process it, because often as well in a separation, one party has left the relationship, just arbitrary figures, 6 months prior. So then all of a sudden we've got the person that's remaining being told, I want to separate. They are 6 months behind the person that has decided that they want to separate. So they're in the emotional state as well. Not only is the person who's initiated the separation in the emotional state and probably wanting to rush things through, but needs to slow down, the person that's left behind needs to be in a position to really, I suppose, get up to speed. So we need to also be mindful of the fact that, yes, you're going through the separation and it's emotional, but so is the person that you're about to separate with. So there's a lot of time, in my view, that's needed for the purpose of healing, getting ready. Really, lawyers don't need to get involved in the heat of the moment, because that is often when things can really, yes, blow out of proportion, and all of a sudden we're kind of reacting rather than thinking and acting in a logical way. So really time, I think, is the best thing. As I said, as long as it's safe, as long as it's not a situation that requires urgency. But even then, there's often still ways of slowing things down, of calming things down. I said to a client the other day, just doing one little thing, and that's disconnecting the electricity from your old house and putting it into his name, is a big thing. It took her an hour on the phone. And I said, just feel grateful for the fact that you did it. It's now out of your name. You're not responsible for the electricity that he's paying while he's living in the house, and feel really happy that you've achieved that. So that's enough for that day. You can just do little things, little steps, one day at a time.
How do courts assess the best interests of the children? Because I remember growing up, you'd obviously have mates and dads, mates' parents and stuff who would get divorced, and the dad would have them every second weekend or something like that, right? So is that still sort of just the case, or the court's taking a bit more of a different view to that? Was it a test, or what actually, how do they make that up?
It is 100% still the test. What is in the children's best interest? There are changes coming in early May that make it that phrase a little bit less used, but it's still, at the end of the day, the best interest. So are the children going to be still together? Are they going to be in their old house? Are they going to be able to maintain a meaningful, safe relationship with the other party? Lots of factors, but certainly less in the new legislation changes that are coming than previously, but things or factors to ensure that the children's development and their relationships and really everything as much as possible stays the same, so that they can continue to be kids while their parents are going through these issues. But at the end of the day, yes, the test is, at this stage, the best interests of the child. What is in the best interest of the child? And so what orders should be made in the children's best interest? So today, for example, I had to tell the court why I thought an agreement that was reached at a mediation was in the children's best interest. My first submission to the court is that the parties reached this agreement themselves. Now, that is not a factor in the Family Law Act. I think it should be. But at the end of the day, the parties reached the agreement. That is always in the children's best interest, that mum and dad reached it. It's not court imposed. It's not imposed by anybody else. It's just what these two want. So that's a great starting point for what is in their best interest. Other factors are what the children want, what what they express to whoever it may be, not just mum or dad, but somebody independent. There are independent children's lawyers who are there appointed by the court to assist the court make an order that is in the children's best interest. And so the children's views can be expressed to them, can be expressed to a report writer, lots of factors, as I say, to figure out what is in their best interest.
No, I'm just generally curious about it because, it's obviously relationships and roles have changed a little bit as well. So it has a softening. Obviously, the general perception would be that most of the time it'd be the lady winning full-time custody or having more favourable custodial arrangement than the man, and that's just it seems to be a few calls from fathers groups and stuff, but it's maybe changing a little bit. But obviously, there's new. Is that new changes coming out more to reflect that, or
that was what happened in 2006 when the changes were big changes. The last big set of changes were made. That was essentially in response to many of the men's groups where they felt that the men really weren't being heard. And so therefore, at that time, the legislation was changed that the court had to consider, is it in a child's best interest for the parents to have equal shared parental responsibility? So that means both parties making decisions about their long-term issues. So where they go to school, what religion they should be brought up with, the big ticket items, heaven forbid they need a kidney transplant. Should the parents be making those decisions equally? Then from that, and this was very much led by the men's groups, should the court then, if the court says equal shared parental responsibility is in the child's best interest, then the court makes an order for significant and substantial time, and that's where the equal time arrangements came into play. A lot of the time we were making orders for the children to live week about in each parent's home. So Monday to Monday with mum, the following Monday to Monday with dad. But that is very much changed. I think in the last probably 5 years, children don't like shared care like that. Generally, they say. Of course, every child's different, every family's different, but a lot of the time, the children just really are feeling like they're going from a hotel one week to a different hotel the next week. So they don't like that. So that part of the legislation is changing, that parental responsibility is changing, so is the court to consider significant and substantial time. Yeah, that's a work in progress. But in answer to your question, yes, there were definitely the men's rights groups having a big say, but it's kind of swinging the other way. Not to say that it's going towards the women's way, but it's really probably more, if anything, the children's voices are being heard more, and the courts are taking much more notice of the children's voices. So, for example, a change to the legislation coming in May is that children over 5 are required to express a view to the person who's appointed to represent them. Well, that was not really ever not even a practice, let alone really a requirement in the legislation. So, the children's voices are very much more significant.
Yeah, the only reason why I asked that is because in Jim's book is he talks about the time when his kids were taken away from him. So the hardest time in his life, he was saying, I think it was like 3 months or 6 months, and the lawyers for his ex-partner's side were using the kids as leverage to get a more favourable settlement, which is what he wrote in his book. So that's the only reason why I bring this up, is because he's very passionate about that sort of stuff, and it was definitely not a good time in his life with that sort of thing going on back then.
No, it isn't, and that's really bad lawyering for people to do that. So is applying for domestic violence orders. People often saying, well, if I have a domestic violence order in my favour, that it's going to be better for me for getting the children more in my care. It's going to be better for me to have more by way of property settlement. Fortunately, I think the magistrates up here, at least, are sort of seeing through that. So it's really not going through as much. But also, it has to be tested then as well. You will not get that from me, I can tell you. That is not a good approach at all. And at the end of the day, I've heard lots of judges say, although it is in the legislation, but lots of judges will say, I don't care that you've got the children in your care more. That doesn't mean that you're going to get more in property settlement. So the tactic is often not working from my experience. But I have definitely heard it, and I think it's terrible lawyering. I must read Jim's book then, huh?
It's in there at the start. I think it's on online. You can download it for free as a PDF, and it's on Audible as well. And I was going to say the other question I had, which is pretty relevant to our franchisees, is they run the business together a lot of the time. The partners, someone might run the books or do the office, or they run it together equally, and then separation happens. and then they lose. Then end of the day, it's not good to see, but then they surrender the franchise and the business stops. It's very rare that it keeps going. So,
really?
yeah.
That's
So,
insane. Yeah.
So do you want to maybe outline some considerations for that thing if you're working with a partner? Maybe what are some things they should have in place maybe before that? And can it continue post one person exiting, and how would that all go?
Absolutely. I think it can continue post-separation. It's a matter of, as I said earlier, we've got to value what the business is. That gets added into the asset pool that essentially is then, I call it the cake. We add that to houses, cars, any big ticket item that are available for distribution. And not everyone's got them, so that's okay as well. But the business will get a value, and then it's a matter of figuring out who gets what. But if it is the case that both parties are working in the business, I can't see why. Okay, so you value it. Just say, for example, let's just use really random figures. The business is worth $10,000. There's no debt attached to the business. We've decided on a 50-50 split. Husband wants to keep the mowing business, so we'll pay out the wife $5,000 because that's 50-50 split of the total asset pool of property settlement. The husband then gets to keep the business, but he essentially buys out the wife. And then we do the paperwork to ensure that the business is transferred into his sole name, and the wife in exchange gets the money for that. But if it's the case that one doesn't want to leave, or maybe this is why they often have to be sold, where both parties want to retain the business. So if that's the case, then maybe it does have to be sold, or the court will have to decide who should get to keep the business. But if it's the case that we're working in the business together and we haven't sorted out settlement, I think you just need to make sure things run the same as they always did. So in property settlement, when we're trying to work out who gets what, we have what's called discovery. So everyone has to disclose their financial situation to each other. So that means that, just for example, if the wife is doing the bookkeeping, husband's doing the manual work, the wife has got an obligation to disclose all of the financial documentation to the husband, who may or may not be aware of it, but that's one of the first things we do in disclosure when we're trying to work out property settlement. So the wife can keep it staying in the business, but she has to know that this is going to still be produced to the husband, so we can figure out essentially what is the value of the business. I just hope that it stays amicable so that you can sort it out and then figure out who gets what at the end of it. That's always the aim. Sometimes people come to us when it's all a bit gone pear-shaped. That's understandable. A really good option is mediation. You don't even need lawyers for that. You just go to a mediator who can assist, and sometimes that can be done even before we get a final agreement. It can be done as a little introduction, in the same way that I would be, as you asked before, Joel, about consent orders, so drafting up a proposal. I it probably wouldn't be me as the mediator, but it would be somebody that we can refer you to for the purpose of helping you figure out who's going to get what at the end of the day. Then that's when I'd come in later on and then do the documents for the purpose of formalizing the agreement. Does that help?
Yeah. And that's something that our franchisees could obviously, it is a concern from them. They can obviously get a free consultation with you guys, which I think is fantastic, and they can get their some peace of mind with it as well. And I was going to outline as well, I think, has there been some new stuff that's coming around transfer of assets? Because I know some people think they were quite clever in the past, and they might know they're going to split, let's say, and then a year before they do so, they shift a whole bunch of assets into different things. Has the laws gotten stricter around that sort of behaviour, and obviously look less favourably if someone tries to do that? Yeah,
I don't think that's ever really changed. I think if you're trying to move assets for the purpose of hiding them, essentially, from just as I said, the discovery purposes, we'll be able to see that we go back at least 12 months. Sometimes we go back 3 years, depending on when things have occurred. But yeah, if all of a sudden we find that we've got a house in joint names that's now gone into one sole name, that doesn't affect really anything, I say. One party still has what's called an equitable interest in that property. So hiding of assets, moving assets around to attempt to defeat someone's interest in property settlement is just not going to work. And yes, if you have to go to court and the court finds that you've done that for the purpose of defeating someone's interest, you are looked not favourably on. And sometimes the court can make an order for costs. Sometimes they can award a high percentage to the person who has been the one attempted to be, I'll say, scammed, as essentially punishment, which is, it's not really a punishment court, but as a way to make up for the bad behaviour of the person that's trying to defeat the interests of the one who is doing the right thing.
I was going to say,
sorry.
Yep. I was going to say, Tracey, so what's the misconception is it about legal services? I think lawyers get all tarred with the same brush, unfortunately. They think, people think it's going to be expensive, they're going to have to really try and drag it out. You mentioned some stuff at the start, which is great about being cost conscious and stuff like that. So maybe what are some misconceptions anyway that you want to maybe address? Because people unfortunately label, I think, lawyers and stuff the same all the time. So
yes, look, I find a lot of the time lawyers don't do themselves justice. Sometimes it is the case where, for example, the one I was telling you about where I said to the client, just get the electricity changed into your name or his name and out of your name one day at a time. The same situation, the lawyer on the other side is looking for discovery. Now, this is just a pretty basic house, we call it house and garden property settlement. We're not talking companies, trusts, certainly not businesses. The lawyer on the other side is asking for discovery upon discovery, is collating bundles of documents for his client, is whatever my client has given under what he's asked for, under what the rules say, it's not enough. I think that comes down to either not secure in what they're doing, making sure that they're covering every single base. It is also maybe a case of overbilling their client. That means that my client's getting overbilled too. What I do in that situation is that I go off the record and I say to my client, and in this case she works in the bank, she is brilliant at her documents. I say, you take over the matter. If you need me to check anything that goes to the other side, I will, but you can go and scan all of his bundle of documents that have come, not yet, but will come. You can read them. You can see if we've got anything hidden. She knows that there isn't. So I'm not going to spend my time looking at it. She can. That means that I don't spend, say, 3 hours going through documents. She can do that. It doesn't cost her anything. She knows what she's looking for. So we come off the record. That's one way to save costs. Another way to save costs is to give the bundle of documents, stay on the record, give the bundle of documents to the other side and say, you go looking for them because, and this is what you need to be looking for. Another way is okay, my client in this case, she's really good at documents. You go and collate them yourself. This is the table that you need to send, showing what you've sent, when you've sent it, you collate it, you do it. So get them to do a lot of the work essentially. Lots of times I get clients to fill in documents, court documents, and I'll just settle them. So for example, an affidavit, which is a party's story, can take a week, really. I'm a bit fussy on them, so it can take me a long time to do them, but I'm not going to charge a client a week's worth of preparing an affidavit. So I give them headings, get them to fill it in. Too much is better than not enough, and then give it to me and I'll settle it. And that can save me a lot of time, obviously them a lot of time and money more than anything. Lots of ways to keep costs down, and I'm really motivated to do that.
No, it's great to hear that, and I'm sure anyone who's listening who wants to use your services will be happy to hear that as well, because obviously we know there's good people and bad people in different industries and stuff, and unfortunately with family law, because it's such an emotional thing,
yes.
People will spend a lot because they just want to win so much sometimes, and even though it's not in the best interests of them or their children.
Yeah, absolutely. And if it ever gets to that, I just tell clients, I'm just not going to take your money for the sake of it. We're not a mouthpiece for our clients. We don't just do what they want us to do and under the guise that we're their lawyer. Our job is to take instructions and to give you advice, and hopefully the two go well together. The best client is the one that listens to your advice as long as it's sensible and takes it on board and really works with you to get the best outcome.
Let's talk about the offer. So obviously there's an offer for Jim's franchisees, which we'll put into the notes, and we'll make a webpage as well that they can apply for that offer. What about members of the public as well?
Absolutely. We're still open to members of the public. I think we've got a bit of a deal that if they're family member or a friend of a franchisee, we'll still give them the discount. Probably probably everything. The 30-minute consult free for everybody. If you're coming through Jim's, then the 25% off the hourly rate. If you take us further, and again, we're not going to be doing everything we can to rack up your costs, but I guess probably it's still going to be quite expensive for members of the public. But that's where you choose us if you need us, and there are definitely other cheaper options, and I'll always consider those when I refer you on to whoever I think you may need.
Great. So what we'll do, Tracy, is we'll leave it there and we'll put all the details in the notes as well. Thank you for joining us today as well. And hopefully people use you because, obviously there's ChatGPT and stuff, and I'm sure some people might think they can get the best advice from ChatGPT and different things like that, but that's not the case. Definitely use you guys and at least have a consult. I think that doesn't hurt in any way if they're not sure, and best to get things in place before maybe something ever happens. So, thank you very much for joining us today.
Yeah. Excellent. I look forward to helping. Thank you, Joel.
Thanks, Tracy.
Thank you.
Thank you for listening to the episode of the Gyms podcast. If you want to learn more about the Gyms Group, head to gyms.net or call us on 131 546 Australia or 0800 454 654 New Zealand. And if you did like the episode as well, please make sure you leave a review or a comment or a thumbs up or a comment on the video as well. We appreciate your support. And until next episode, we hope you have a great week.